Good afternoon, everyone. First, I want to start out by just thanking everyone, particularly thanking Professors Powell and McNeil for inviting me, for conceptualizing this wonderful conference today, and for Dean Crawford for his support of the conference, and for everybody here. It has been just a wonderful day being here and hearing all of the great speakers. I'm particularly honored to be at a conference that's featuring the books of two of my good friends and colleagues, Paul Butler and James Foreman. Paul earlier said that I was his mentor. That's actually not true. Even though I'm older than him, he's been my mentor. I started out as a law professor at George Washington, where he was a professor, and he taught me everything about being a law professor and helped me so much with my writing and everything. So thank you, Paul. Their books are phenomenal. If you have not read Chokehold or Locking Up Our Own, please read both of them. Also, Professor Butler's first book, Let's Get Free, A Hip-Hop Theory of Justice, is also phenomenal work. I recommend that to you as well. So I'm just honored to be here in this great discussion, and also just to hear the discussion that's been going on among you. I mean, you all have been, I can't wait to engage with you on a discussion of this work. And so timely, I also want to thank, she just walked in, my cousin Faye Owens, who is a longtime resident of Louisville, and who has been an educator and a principal in the Louisville school system for decades, and is not only my cousin, but my godmother, because that's how we roll in my family. And so this gave me an opportunity to see her, and so I'm happy to have her here today as well. So I want to talk a little bit about the book and about my own contribution. So I was asked a few years ago if I would be interested in editing and sort of compiling essays and editing a volume that would attempt to contextualize all of the horrible killings of black men and boys over these past few years. And of course, those killings, as most of you here know, have been going on since the time of slavery, but it's just in recent years, primarily because of cell phone cameras and social media, that it's really come to the attention of this country and that people have actually believed what's been going on. But these killings have been going on since we've been here in this country, since the time of slavery. But when I was asked if I was interested in compiling such a volume, I immediately said yes. Because there's no issue that is more important to me than the unfair treatment of black and brown people in the criminal justice system at every step of the process, from arrest through sentencing. So I thought about who I would ask to join me in this project, and so I thought about all of the writers and scholars and activists and agitators and litigators that have been out here writing and talking and thinking and working on these issues, and in many instances living these issues. And I reached out to them, and I was very fortunate that so many of them said yes. And so I want to take this opportunity to thank the contributors to this volume, because it's really their work that makes the book. So I thought what I would do is start out, let me just, as way of background, as I mentioned, I'm the editor of the book, which means that I sort of conceptualized it, chose the authors, and edited it. I also wrote the introduction to the book, and I contributed my own essay to the book. And so I thought, to give you a sense of what the book is about, that I would read a brief excerpt from the introduction of the book, and then spend the remainder of my time talking about my own contribution to the book, which is about the prosecution of black men. Michael Brown, Eric Garner, Tamir Rice, Walter Scott, Freddie Gray, Sam DuBose, Alton Sterling, Philando Castile, and Terrence Crutcher are just some of the names on a long list of unarmed black boys and men who were killed by police officers in recent years. Although black men have been the victims of violence at the hands of the state since the time of slavery, technology and social media now permit us to literally bear witness to these killings repeatedly. Millions of people watched the video of a police officer choking Eric Garner to death as he struggled for air. Similarly, millions have watched the video of a police officer shooting Walter Scott in the back as he ran for his life. Who can ever forget the grainy footage of Tamir Rice, the 12-year-old boy who was shot by a police officer while he played alone with a toy gun in a park near his home? Two videos, one from a police helicopter and the other from a police dashboard camera, show Terrence Crutcher walking away from police officers with his hands raised high in the air just before he was shot and killed. These images have evoked feelings of fear, sadness, and outrage, and serve as a reminder that the lives of black men and boys continue to be devalued and destroyed with impunity at the hands of the state. To date, not one of the police officers who killed these men and boys has been convicted of a single crime. And when I wrote this, I mean, many of you may be thinking now about the officer Michael Slager, who pled guilty to a civil rights violation for killing Walter Scott in the back. He pled guilty to a civil rights violation after a jury came back, not convicting him, after a hung jury came back. So this statement remains true. Not a single one of them has been convicted of the murder of these men and boys. From the arrival of the first slaves in Jamestown in 1619 to the lynchings of the 19th and 20th centuries to the present day, black boys and men have been unlawfully killed by those who were sworn to uphold the law and by vigilantes who took the law into their own hands. The National Museum of African American History and Culture, which opened its doors on September 24, 2016, includes exhibits that tell the story of many of these killings, yet these killings are not just a part of African American history. They've continued well into the 21st century, almost 400 years after the beginning of slavery, and persist with remarkable frequency and brutality during a time when America elected its first African American president. Many of these race-based killings have inspired and reinvigorated movements for change. The brutal killing of 14-year-old Emmett Till in Mississippi in 1955, the murder of civil rights activist Medgar Evers in 1963, and the assassination of Martin Luther King in 1968 all serve as markers on the civil rights movement timeline, as did so many other killings of black men and women by white racists. Each tragic killing sparked nationwide protests and renewed activism in the struggle for civil rights and racial justice in the United States. The killing of 17-year-old Trayvon Martin in 2012 was a pivotal marker of racial violence against black men in the 21st century. As you all know, Martin was killed by George Zimmerman, a white man who called the police when he saw Martin simply walking in the neighborhood. At first, he wasn't even charged with the crime. After a number of protests, he was charged, but a jury ultimately acquitted Zimmerman. The killing of Trayvon Martin, the initial failure of the prosecutor to charge Zimmerman with a crime, and Zimmerman's ultimate acquittal captured the attention of the nation. President Obama even weighed in, stating, quote, "Trayvon Martin could have been me 35 years ago," unquote. Martin's killing also inspired the phrase, "Black Lives Matter." The phrase trended on Twitter and all forms of social media and was displayed on posters carried in protest after Martin's killing and after every killing of a black man or woman by a police officer from that day forward. Black Lives Matter ultimately became a social justice movement. Many unarmed black men and boys have been killed since Trayvon Martin's tragic death 5 years ago, and many of these killings occurred after police officers arguably engaged in racial profiling, stopping and harassing these men for no explainable reason other than the color of their skin. In all of the cases where black men were shot and killed, the police officers claimed that they felt threatened, even though the men were unarmed and often running away or retreating. In almost all of the cases, the police officers were never arrested or charged with a crime. The tragic killings of Trayvon Martin, Michael Brown, Eric Garner, Walter Scott, Tamir Rice, Freddie Gray, and others served as the catalyst for this book, but these killings also inspired us to think about all of the ways that black men are policed in the broad sense of the word, heavily and harshly at every step of the criminal process. In fact, black men are policed and treated worse than their similarly situated white counterparts at every step of the criminal justice process, from arrest through sentencing. These unwarranted disparities exist whether black men are charged with crimes or are victims of crimes. Police officers stop, search, and arrest black men far more frequently than white men engaged in the same behavior. Prosecutors charge black men more frequently and with more serious crimes than white men who engage in the same behavior. And there are disproportionate numbers of black men in the nation's prisons and jails. Criminal defendants, regardless of their race, are punished less harshly when their victims are black men. So the anthology explores and explains the policing of black men from slavery to the present day and at every stage of the criminal process and beyond. So many people will ask me, why focus on black men, right? Because black men are not the only people who are treated harshly by the criminal justice system, and that is absolutely true. They are not the only people of color. They're not even the only people of color to be treated worse than their similarly situated white counterparts. Black women, Latinas, Latinos, Native Americans, and other people of color also experience violence at the hands of the state and discriminatory treatment in the criminal justice system, as do people who are gay, lesbian, and or transgender. So the book's focus on black men in no way trivializes the experiences of all people who face these harms. However, while acknowledging that all of these groups have been and continue to be oppressed and discriminated against, the book focuses on black men because in many ways the experiences of black men in the criminal justice system is unique. And the most noticeable difference is that they are impacted more adversely than any other demographic in the United States at every step of the process. So black boys, for example, are disproportionately arrested and detained. In fact, black boys, and my friend up here, who spoke so eloquently early this morning can attest to this, black boys are actually discriminated against more than black men in the system, and Kristen Henning's chapter in this book explains that so well. They're more likely to be referred to the juvenile justice system than white children. They're more likely to be charged as adults than similarly situated white kids who engage in the same behavior. Black men are disproportionately arrested. African Americans are 2.5 times more likely to be arrested than whites. And 49% of black men, almost half, can expect to be arrested at least once by the age of 23. Black men are more likely to be killed or injured during a police encounter. In fact, black men are 21 times more likely to be killed by police than white men. Black men are disproportionately imprisoned and receive longer sentences. And of course, African Americans receive the death penalty disproportionately as well. So for all of those reasons, the book focuses on the plight of black men and boys. Now, I want to spend the remainder of my time talking about my own contribution to the book. It was a chapter called The Prosecution of Black Men, and there was some discussion this morning about prosecutors, and I've spent pretty much, over 20 years, my entire life in the academy writing about prosecutors. And the reason for that is I used to be a public defender in the District of Columbia. I was a public defender for 12 years there. And one of the things I noticed and was just sort of shocked by was the incredible power and discretion that prosecutors have in the criminal justice system. They appeared to me to control the system. And so I really focused my scholarship and work on prosecutors and the power that they wield. And it is my conclusion that prosecutors are the most powerful officials in the criminal justice system, bar none. I believe that they control the criminal justice system through their charging and plea bargaining powers. So there's a lot of focus on police officers, and there needs to be that focus for all the reasons that we know, for all the reasons I was just talking about, the profiling, the awful killings. Police officers have an incredible amount of power and discretion on the street to stop and search and engage in behavior that ultimately has led to many of these unwarranted killings that I've just talked about. And so we must focus on police officers, but we have to focus on prosecutors too. Because although police officers have the power to bring an individual to the courthouse door, it is the prosecutor who decides whether they remain in the system and exactly what happens to them when they get in the system. Prosecutors decide whether an individual is going to be charged with a crime. Everybody thinks police officers, what's a police officer going to charge me with? Police officers can't charge. They recommend charges. It's the prosecutor who decides. And it's very easy for prosecutors to bring charges. They have to meet a very low standard, a standard called probable cause. Those of you who are law students who've taken criminal procedure know what that is. It's a very low standard, more probable than not. It's the same standard that police officers have to use, that they have to meet in order to arrest a person. That's the same standard police officers, that prosecutors, have to meet to bring charges. So it's very easy for them to bring charges because it's such a low standard. They can charge all kinds of offenses that they may not ultimately be able to prove at trial, because in order to prove it, of course, they've got to meet the much higher standard of proof beyond a reasonable doubt. But they can pile on those charges, and they don't even have to charge if they don't want to. So there might be probable cause. There might even be proof beyond a reasonable doubt. It's totally up to their discretion to decide whether to charge, what to charge the person with, what the charges are going to be. They have total discretion. So just to give you an example, let's say a cop arrests someone who has 4 or 5 bags of cocaine on them. And they bring the case to the prosecutor, and they may decide to recommend to the prosecutor that the prosecutor charge a felony of possession with intent to distribute. Because if you got a lot of drugs on you, that it tends to be easy for the prosecutor to prove that you intended to sell it rather than it just being possession for your own personal use. So the police officer may recommend the felony possession with intent to distribute, and pretty easy for a prosecutor to bring those charges. Probable cause, cop, arrest them, they had them on them, they can bring the charges. But they can also just say, you know what, I don't want to, I'm not going to charge, I'm going to let this person go. They can do that if they want to, and they often do. Or they can say, well, I think I'll just charge this person with a misdemeanor, which only carries a year, rather than that felony possession with intent to distribute, which, depending on the jurisdiction, might carry a mandatory minimum 5 years, 10 years for each count, for example. So you see the range of power that a prosecutor has. And they don't have to justify that decision to anyone. They don't have to go to court and say, Judge, may I? This is what I'm going to do, and this is why I'm doing it. They make that decision behind closed doors. So you can see how that discretion can create disparities in the system. Maybe they want to give this one person over here a break, right, whose daddy they know or who looks like them, who they can empathize with. I used to carry a little drugs when I was young, too. I don't want to ruin this one's. I don't want to ruin Todd's life over here because he's got college in front of him. But Jamal over here, I'm going to give him a felony. I'm not even saying it's that conscious of a decision. I'm not. A lot of times, I think it's implicit bias, which we can talk about a little bit, where they're unconsciously empathizing with one defendant, whereas the other one they don't quite have the same empathy for. They may not even realize they're doing it. Maybe they do, maybe they don't. Sometimes that may be part of it. But you can see how that discretion can create those kinds of disparities. And that's just the charging part of it. Then we get to plea bargaining. I think it was mentioned earlier today. How many cases are resolved by way of a guilty plea? The plea bargaining process is also totally within the power and discretion of prosecutors. They decide whether to give the person a deal, what that deal is going to be. They don't have to offer a plea. They can if they want to. They don't have to if they don't want to. They can decide what that deal is. The judge has no control over that. They don't have to justify it to anyone, and the decision is made behind closed doors. So if it's really easy for them to pile on charges, to charge, as many counts as they want, even if they know they can't ultimately prove it, it gives them this tremendous advantage at the plea bargaining stage, right? Everybody here know what plea bargaining is? Right, so, it's very easy for them to say, you know what, I've charged go to the defense attorney, I've charged your client with 5 mandatory minimum counts of possession with intent to distribute. They're facing 50 years in prison. But I tell you what, I'll make a deal with you. I'll dismiss 4 of them if your guy pleads to just 1. Of course, that just 1 might carry 10 years. But you can see how even an innocent person would plead guilty when they're faced with 50 years in prison, because going to trial is risky business. Yeah, you've got a constitutional right to go to trial, but you don't know what a jury's going to do, right? They may come back with guilty on all of them, and then you're facing 50 years. So people do feel this incredible pressure to plead guilty. That's why 95% of all criminal cases are resolved by way of a guilty plea. 95%, right? People watch all these versions of Law and Order that come on, Law and Order, SUV. I can't even keep up with all of them. And they think all these trials are going on? No, there's not a lot of trials going on. There's a lot of guilty pleas going on because people feel pressured. You know, being represented by public defenders who may be hardworking, zealous advocates, may or may not be, but even if they are, a lot of them don't have the resources to investigate the case, and the way the system works is so unfair. A prosecutor can go, oftentimes they'll put a time limit, a deadline on the plea. They'll come to the defense attorney, I'll make a deal with your client, but you got to tell me today whether he's going to take the plea. Well, the defense attorney might say, wait a minute, I have an ethical duty to investigate this case to find out whether my client has a defense. And the prosecutor said, well, too bad, 5 o'clock and the deal's off, take it or leave it. And so it puts defense attorneys in the untenable position of advising their clients when they can't really advise them because they don't know. You know, they can say to the client, you know, you may have a defense, but I got to tell you, you got this deal, you know, and it's expiring at 5 o'clock. I mean, this is what passes as justice in the United States of America every day in courtrooms around this country. And it is the control, the power, the discretion of prosecutors, I tell you, that is running this system. Right, and everything I just described, by the way, is legal, and there's no legal challenge to anything I have to. This is not. I haven't gotten to prosecutorial misconduct. That's a whole other story that I don't even have time to talk about. What I just described to you today, there is nothing illegal about prosecutors doing. Is it just? No, it's unfair, it's unjust. The decisions create disparities. Intentionally or unintentionally, frankly, I don't think prosecutors go in there every day saying, you know what, I don't think it's that simple as, oh, here's a black defendant, here's a white defendant, I think I'm going to go after the black defendant. I don't think it works like that. I think oftentimes they're unconscious decisions, but that doesn't matter. I don't care if it is implicit bias. It's wrong. It creates an injustice, right? So the fact that they are not intentionally doing, I don't think that makes them blameless. It's still their fault, right? Even though they don't intend to do it, right? So, you know, there's a Bible verse that says, to whom much is given, much is required. And so they have this power. So to me, they have an incredible responsibility, in my personal opinion, to fix this mess. I mentioned to you how oftentimes the decisions can create racial disparities. I mentioned an example involving defendants. The same can be true, by the way, of victims, right? So, you know, a lot of times prosecutors, and let me just say this too. I think a young man up here mentioned about the race. A lot of times things look race neutral. So sometimes there are actually race neutral factors that create these disparities. And I'll try to give an example of that as well. So the American Bar Association has published something called standards for the prosecution function. They also have standards for the defense function. They have standards for the judicial function. And what they are is sort of guidelines that prosecutors are supposed to follow in order to, you know, do their jobs the way they're supposed to do them. And so they list all these factors that prosecutors are supposed to consider when they're deciding whether to charge and what the plea bargains are. And so they say things like that prosecutors should consider, for example, the victim's interest in prosecution in deciding whether to prosecute a case. So in other words, the victim doesn't get to decide whether the case is prosecuted or not because it's the state's decision. But the Bar Association said, well, you should take the victim's interest in prosecution into account. So for example, if I'm a victim and I say, you know what, I just want my window. Yeah, this person broke my window, destroyed my property, but I don't really want them to go to jail. I just want my property fixed. So that's something the prosecutor can take into account. They can say, well, the victim's not that interested. Tell you what, I'll dismiss the case if you pay for the win. So that's something they can take into account, right? Another factor, the strength of the evidence, right? The likelihood of getting a conviction. So in other words, if you don't have a lot of evidence and it's not likely you're going to get a conviction, the idea is you don't want to waste the taxpayer's dollar going through a trial if it's not likely you're going to get a conviction. So that's a factor that prosecutors are supposed to take into account. But how do they decide the likelihood of getting a conviction? Well, let's say they've got 2 cases, both of them involving a robbery, And one of them, the victim is a white, middle-class, well, if it's a lawyer, probably middle to upper-class lawyer, right? He's robbed of his briefcase as he's walking down the street. And so there's an arrest, and the prosecutor sends a notice to the lawyer and says, I want you to come in for a witness conference. I'm going to put you in the grand jury. Lawyer shows up early, right? He's not on time, he's early. He's got his suit on, right? I want this case to go forward. The prosecutor interviews him. He's articulate. He makes a good witness. And the prosecutor's like, if I put him on the stand, I'm likely to get a conviction because he makes a good witness. He doesn't have any convictions on his record. I'm going forward with that case. I'm going to prosecute that case, right? And let's say there's another case, right? African-American kid, let's call him Paul. Sorry, Paul. And let's say he was robbed of his jacket on the street. And they sent a notice to his house. Paul doesn't show up. And there may be a lot of good reasons why Paul doesn't show up. First of all, he may not have gotten a notice because he may live in public housing where he doesn't even get his mail. Number two, he might work, he might do day work, so he doesn't have time to take off in the middle of the week and go down to the prosecutor's office, or he'll lose his job. So maybe that's why. Whereas the law partner, he don't have to show up for work. But, Paul got to show up. He's going to lose his job. Or maybe he doesn't want to go down there because, his cousin was prosecuted by that office. He's not necessarily comfortable going down there. He doesn't feel that comfort, so he doesn't show up. Prosecutor's like, he didn't show up. Guess he's not interested in prosecution, right? The victim's interest in prosecution. Or let's say he does, so I'm going to dismiss the case. I'm not going to pursue his case. Or let's say he does show up, right? But he doesn't have on the suit. He doesn't speak the king's or the queen's English. Maybe he's got a conviction on his record. And the prosecutor's like, well, he's not going to make a good witness. I don't necessarily want to put him on the stand, so I'm not going to go forward with that case. Is that an intentionally racist decision? Some might say it is. Some may say it really isn't, right? He's using this race-neutral factor that, after all, the ABA says he's supposed to consider these factors. And so you can see how complicated this gets, right? That's a race-neutral reason why they're not going forward. But does it have a racial impact? Of course it does. Of course it does. This is what the young man up here was talking about. Of course it does, right? And so the prosecutor's not blameless. So, I could go on. I'm going to stop there with that because I know I want to hear so much from the other panelists here. But, what do I have to say about this? I mean, ultimately for me, and we're talking about, structural inequality. And I've heard a lot this morning, about how we need to dismantle the system. And I'm all for that. We do need to dismantle the system. But we need to know, I'm really curious to know and want to hear what people have to say about what does that look like? What does it mean to dismantle? It's easy to say, let's burn the mother down, dismantle the system. And I'm with that program. But, what exactly does that look like, right? Because literally you're not going to even burn down the system. As Paul pointed out, you're going to get locked up and then we right back in the same system. So what does dismantling the system look like? And I'm not saying this facetiously because I believe it deserves to be dismantled. But we got to think about, what does that mean? What does that look like? And what does that mean? In the meantime, I'm going to use a word that everybody here was earlier saying they're not with, and I'm going to use the R word, reform. I'm trying to find another word to use because when you start saying reform, people start rolling their eyes. But this is what I'm talking about. And I'll take just a few more minutes if I can before turning it over. So we talked a little bit this morning about this movement. I wouldn't call it a movement because it hasn't happened enough yet for it to be called a movement. But there is a movement towards, I will say, change in prosecution. And so earlier it was mentioned that there's a PAC, and I mentioned it in my comments, called the Justice and Public Safety comment. Talk about branding. It's called the Justice and Public Safety PAC for a reason, even though it's left because they're using words that we talk about the use of words that have images. Justice, who can be against justice and who can be against public safety? So that's what they call it. But it's basically funded by George Soros, who's put millions of dollars into targeting bad prosecutors who are out there perpetuating mass incarceration and racial inequality and racial disparities, and seeing if there are individuals in those communities who are truly progressive prosecutors who are about transformative change and backing those people. And unfortunately, politics means money. Yeah, unfortunately. So Larry Krasner was mentioned, and he is to me, Larry Krasner is a transformative prosecutor. He's white, by the way. And yes, we need to get more people of color, but Larry Krasner is white, former defense attorney and civil rights lawyer, never prosecuted a case in his life, but he ran for DA. And this PAC put over $1 million into the race. TV ads, radio ads, funding people to knock on doors. They got the buy-in of local groups on the ground. The Black Lives Matter movement of Philly backed them, Color of Change, and other organizations. And he won overwhelmingly in Philadelphia. And he started in January. And if you Google him, you will see amazing things that he is doing. He started out by firing 31 of the prosecutors in his office who were not with the program. He's like, okay, you're not with the program, bye, Felicia, or whatever their names were. And not every prosecutor can do that because a lot of times they're unions and stuff, but he was able to do it. And he's just fired them. Some of those people had been there for decades, and they were like, He's like, bye. And so he's now trying to hire people with his vision, and he set down serious policies where, like, I'm talking about you're not going to charge people, like totally decriminalizing marijuana. Like we're not even charging that anymore, period. Money bonds for low-level offenses, nope, we're not doing it, we're not backing it. Recently sent forth a memo that said whenever a prosecutor goes into court and asks for time, they have to justify, they have to say how much it costs to incarcerate that person, and they have to justify to the judge why they're asking for that person to be locked up and why they're justifying spending that money on incarceration versus building schools. They have to say this in court by order of Larry Krasner. I could go on and on. So it's transformative. So, this is somebody using the democratic process who got in that position and is transforming. So I do believe if you have someone, and not everybody who's calling themselves a progressive prosecutor is progressive. I'm just going to use Larry for now. But I'm talking about somebody like that who's truly about transformation. And it can make a difference. And ask the folks in Philly now who got out when he said, y'all, I'm not supporting you being. Ask, what's the rapper's name? McNeal, thank you. Who was just locked up repeatedly over some crazy probation violations. Ask him what he thinks about it now that he's free thanks to what Larry Krasner did. So yes, revolution is important, but I also believe that we can use the democratic process to make change. Sadly, George Soros had to come in with $1 million, and that's problematic. I mean, we get George is going to, I hate to say it, but he ain't going to be here forever, and there's not a lot of millionaires, and so why should we have a system where we have to put $1 million in there for it to work? That's crazy. So that's a problem, right, that I don't have an answer for. But I do think it's about the hard work of democracy, and democracy is hard work, and it's particularly crazy these days, right? So it means what this brother here was talking about, like running for office, right? And what Elizabeth talked about, the writer who said every cook, what was the name of the word? Every cook can govern, because you don't have to, go to Harvard or whatever to be a leader in your communities. Right? You don't have to be, and sometimes it's best that you not be. It needs somebody who is of that community, right? And so I think we have the ability to make change, transformative change, incremental change. We need all of those changes in our community, and it's my view that it needs to start with the prosecutor. So I'll stop there, and I look forward to hearing from the other panelists.
Good afternoon. So my name is Laura McNeil. I'm currently an associate professor of law here at the University of Louisville, and I also serve as a law and policy analyst at the Charles Hamilton Houston Institute for Race and Justice at Harvard Law School. So the title of my presentation today is Disrupting the Cycle, Piercing the Prosecutorial Box. And so what I'll be doing today is trying to bring some modern-day examples, not modern-day examples, but some very tangible examples to some of the structural issues that Professor Davis highlights in her textbook. I want to just start out a little bit with the summary, but I'll essentially be providing information regarding a research study that I'm currently conducting on prosecutorial misconduct. So as the coalition to dismantle mass incarceration grows in numbers and strength, there's attention increasingly being focused on the enormous power wielded to prosecutors. Their influence in determining who is charged, who may plea out, who goes to prison, and for how long is both underestimated and underexamined. In a recent editorial, David Brooks in the New York Times wrote that the historic levels of imprisonment in this country are not, as many assume, the result of mandatory minimums, drug laws, or even the 3 strikes laws. So what explains it? His theory is it's prosecutors. District attorneys and their assistants have gotten a lot more aggressive in bringing felony charges. 20 years ago, they brought felony charges against about 1 in every 3 arrestees. Now it's something like every 2 in 3. So we've seen an immense increase. Brooks went on to note that while there are plenty of theories about why prosecutors are more aggressive, none of them can be proven because the prosecutorial world is largely a black box. Angela Davis, who just spoke, has voiced similar sentiments in her book, Arbitrary Justice, The Power of the American Prosecutor. She writes, quote, "During my years at the Public Defender Service, I noticed that prosecutors held almost all the cards and that they seemed to deal with them as they saw fit. Although some of them saw themselves as ministers of justice and measured their decisions carefully, very few were humbled by the power they held. Most wanted to win every case, and winning meant getting a conviction. So I contend that comprehensive criminal justice reform in this country must encompass fundamental changes in the incentive systems and cultures of our prosecuting attorney offices. We need to help them move away from an emphasis on winning and focus more on justice. And we also need to make sure that prosecutors understand their impacts of their decisions on individuals, families, the communities they serve, and the broader society. So the goal of my study is to identify and more fully understand the pressures, the incentives, and structural factors that affect the decision of prosecutors in states with the highest rates of prosecution and the greatest racial disparities in prosecution and sentencing. I believe that the first step is to hear directly from progressive prosecutors, which is who we targeted for this particular study, who've made decisions to change their culture within their offices. So essentially we conducted, and I say we, my colleague and I, Johanna Wald, is the co-researcher on this project. We conducted interviews that are structured to elicit insights into the daily incentives and pressures, as well as the institutional factors that determine prosecutorial decisions to charge, to plea bargain, to make sentencing recommendations, and so on. I also examined where prosecutors see opportunities for reform, the need for oversight. So I consider this research to be extremely important and absolutely necessary to pry open the black prosecutorial black box and better understand the drivers of these widespread practices among prosecutors of overcharging and pushing defendants to accept plea deals even when they're innocent. This research is geared to continue the much needed and long overdue public scrutiny now being paid to the role of prosecutors in creating and perpetuating our current system of mass incarceration, and more important, point the way towards that dirty word Professor Davis referred to as reform. I'm just going to start out today. I was going to start out with just phase 1 of the study. So a lot of people ask me, what compelled you to get involved in this research? And it's a pretty obvious response. It's the numbers. It's knowing that although blacks only make up 40% of incarcerated individuals, yet they only represent 13% of the U.S. population. Knowing that African Americans are incarcerated 5 times the rate of their white counterparts, this data has been here for years. It has been despairing, as we saw highlighted in the documentary, yet I don't see a lot of research being conducted, empirical research, looking at the drivers behind this. Who are the gatekeepers to our criminal justice system? Who decides who gets charged? Who decides whether or not you go to a diversion program as opposed to being locked up for a low-level defense? And so I think this research is very important in addressing some of those questions. So I thought it was important. Hopefully my mic is working. Is it working? I figured it wouldn't. So I'll just hold it up. There we go. So Professor Davis's book does a wonderful job at critiquing or providing a critical analysis of the structural, political, social, and cultural factors that are impacting or rather driving this mass incarceration that we see. She talks about, there's an author, Catherine Russell Brown, talks about implicit bias and what role explicit and implicit bias plays. I currently conduct implicit bias workshops through the Institute at Harvard, and you would be astonished. We've done implicit bias workshops with judges, prosecutors in New York. We had them take an implicit association test prior to our training, and over 90% of them have racial bias that is unconscious, and the implications of that is quite disturbing. We've also, there's a great research done by Justin Levinson, and he talks about the presumption of guilt that is imposed on African American males. He has a great study he did where he gave a group of judges pictures and said, who looks more criminal? And as Professor Butler pointed out in his presentation earlier, African American males, dark skin, with larger features, exaggerated features, larger nose, fuller lips. And these are the people, the gatekeepers to our criminal justice system that have these biases. Again, some of them are explicit, as we've seen, but some of them are implicit, and to me that's even more dangerous, when you think you're doing good and you're actually doing more harm. The excessive use of force by police, as we saw in the recent incident in Sacramento, these are all driving forces that are exaggerating or rather exacerbating the current structural inequalities that we see. And Professor Davis's book also does a wonderful job. There's an essay by Brian Stevenson, and in that essay, he talks about some of the historical roots in this presumption of guilt that is imposed on African American males. And I think what bothers me the most about the presumption of guilt is that it starts so young in the school to prison pipeline. And looking at how, with the Tamir Rice, if you listen to the initial report by the police, he described this little boy as a 19-year-old male. And so there's this inherent fear, super predator of a child, serving as enough of a fear for him to feel that he needed to shoot immediately. When you look at, as well, you see these patterns of, again, African American males starting out getting harsher sentences while they're in K-12 schools, the criminalization of normal adolescent behavior. Since when does a paper fight warrant a school-based arrest? When it's Jamal, it's Jamal's, he's a problem kid. We need to get tough on him real quick. As Nancy Reagan says, get tough on crime. But when it's Kevin, he's having a bad day. And so we see how this starts at a very young age and is perpetuating right into adulthood. Professor Davis's book also does a wonderful job, an essay talking about racial profiling, the grand jury process, and it ends with her very compelling essay on the role or the important role of prosecutors. And so I think that these things are very important. I'm hoping that the research that I'm going to highlight today will just add another small piece to this important research. I did want to also stress, too, what I've seen has been a very disturbing pattern as well is prosecuting attorneys that literally look like defense attorneys that are dressed up as prosecuting attorneys. With the Michael Brown case, I remember being completely thrown back and appalled. I was like, is he representing some of the information that we found? So essentially, this study is operating in 3 phases. So the first phase was a qualitative study, which is what I'll be sharing today. So we interviewed 25 prosecuting attorneys. There were 13 men, 12 women from Boston, Miami, Los Angeles, Alabama, Ohio, Michigan, New York, Chicago, and Memphis. And essentially, what we're doing in the second phase is we are implementing a survey, using a Likert scale, and we're going to distribute it to 2,500 prosecutors. So it's going to be a much larger scale of a project. And then the third phase, we are doing case studies with very progressive prosecutors, such as Chicago's current prosecutor, just to kind of understand the prosecutors that have built their office on reform platforms. How are they doing? What's working? What's not working? What are some of the challenges? So one of the things we wanted to find out is what are some of the reasons that prosecutors enter the field? Why do you want to be a prosecutor? And so we asked students that want to currently go into prosecuting positions, as well as, again, former and current. And so these are four themes that emerged. They want to promote equality. And I said, okay, what do you mean promote equality? That's a very kind of touchy-feely term. And essentially they said they wanted to make sure that the prosecutorial side was just and fair. One person said, and this is a direct quote from an interview, "I feel that African Americans were underrepresented in the district attorney's offices. I saw how sometimes you can see prosecution that were made that definitely failed to realize alternative approaches to actual charges, specifically felony charges. I also saw the discrepancies in how minorities were treated as it related to criminal matters as opposed to their white counterparts." And so a lot of our, there was an overwhelming majority of our study participants that said we really want to promote equality. So they entered the field for what we all would deem are all the right reasons. Civic duty, many of them expressed, I want to make sure that our communities are safe, that my community is safe. I want to confront the bad guys. We had a lot of participants state that, and improve public safety. And then a lot of them also said they really wanted to regender trust and support within their communities for the police department. Sense of purpose, that was another emerging theme from this qualitative study. So they wanted to make a difference. They wanted to do something they felt that matters. And then many of them are career aspirations. They said, I knew when I went to law school I wanted to be a prosecuting attorney. And so it was very interesting hearing what are some of the driving forces on why you want to enter the field. And then we learned, after we explored the incentives and pressures, what are some of the reasons they're leaving the field? Why is the prosecutorial field, more than 90% white males? And so they were able to reveal a lot of the challenges that contribute to that. And so the next thing I want to focus on is another aspect of this particular study is, what are the rewards and incentives? What drives, what is rewarded in your office? What is considered to be something, what do you all aspire to be? Where are your values placed within these offices? And so one of them was trial skills. And when I first heard that, I thought, this is great. I want you to be a good trial attorney, and, this is sounding very positive. But as we begin to unpack that a little bit more, what we found is that they said they felt pressured to rack up a lot of trials. You're rewarded by how many trials you won and how long you sent people away. So we even had offices that have a board, and they have pictures up of all, under each prosecutor's name, all of the convictions they've made. And it's a competition. Of course, these people that shared, we promised to maintain their anonymity, but we were shocked. Another office, there's a tie, and in each, you get to wear the tie for the week based on the number of wins and prosecutions you get. And so they said they felt a lot of pressure to get the win, again, focus on winning versus justice, as well as they were judged based on their efficiency in moving the docket. So they're measured by the speed with which they were moving cases, which they said, of course, made them feel pressured to say, we need to close this case, I need to get you to plea. Even when they knew the person was not guilty, they felt pressured to get the plea from the individual. So they said their performance in terms of how they were evaluated in doing their jobs was largely based on, again, how many cases they won, how tough the sentences were, and they said there was just an overwhelming culture of winning versus justice. Another thing that really caught us off guard in this study, and it still wakes me up at night, is the complex relationships with police and FBI agents. And so we wanted to know, what are the dynamics with respect to that particular relationship? And so this is just, two quotes as just to kind of capture what the field looked like in our participant pool. But they said, quote, "I felt intense pressure from FBI agents who I needed to give me cases. If you're a 27-year-old prosecutor with a 45-year-old FBI agent supplying you with cases, there's power dynamics in play." Another one, young prosecutors look up to police officers. For a prosecutor with no ties to the community, they're not going to second-guess police officers. And so, you know, we really wanted, we spent a lot of time trying to explore what we perceive as a very incestuous relationship between prosecutors and police officers. And what we learned is that the power dynamics are inevitable. They discussed and shared how the pressure by police officers to prosecute, to legitimize state violence, especially in instances of excessive force. You know, they're saying you need to make this stick, you need to legitimize this state violence. And so it really, and again, these are just snapshots. There's a full research report that we'll be uploading to the Institute's website, but it really captures how problematic these systemic inequalities are and how they play out in terms of perpetuating the mass incarceration we've heard about today. So I don't want to depress everyone, so I do want to change the tone a little bit. So what's nice is that many of them talked about aha moments. These are the individuals that have left the field, and we asked them, you know, what was that aha moment where you said, it's time for me to exit, I'm doing more harm than good. And so these are just some quick emerging patterns for those aha moments. The individual said, "We hadn't stopped the drug trade, we just replaced it." It was by the same story over and over again. Over time, I changed my mind. Winning a trial was supposed to be the moment of joy and accomplishment. You stand up, you hug, and laugh, but I felt crushed. This was one big swamp of tragedy. There is no joy in this. Another former prosecutor said, "I couldn't change the mind of my colleagues that if you do the crime, you do the time. Too bad if there were extenuating circumstances. If you can charge them with a felony, then you do so, even if it's not really serving any purpose." And so one thing about that was interesting is the prosecutors said that they felt very strongly about this, again, this pressure of getting a conviction, feeling like they were doing more harm than good, and just really struggling with how do I, you know, this isn't why I came here. If you think about in the beginning when I discussed there are reasons for entering the field, these aren't those reasons, right? Some more examples. 6 years ago, 6 years was long enough. I became less enamored and I saw these heavy sentences coming down. I was supposed to say congratulations. I didn't feel it. I couldn't get behind slapping people on the back and saying, way to go for getting 15 to 20-year sentences. And so these people described this, you know, very disturbing culture of, you know, again, we don't really care about dispensing justice. What we care about is getting the win. Last one. One case pushed me over the edge and overwhelmed me. One mother had a son who was killed, another who was killed. She lost both sons. They were from the same community. Our approach was not working. It was not solving the problem. And so one thing the prosecutors overwhelmingly shared is the lack of funding for programs, for diversion programs, and people that were coming in, first offenders with low-level defenses, with drug problems, being locked up, and how they said there was just a pattern of, you know, we don't feel like we're doing what we came here to do, and this is not part of, you know, making sure our communities are safe. We're locking up people with mental health issues. We're locking up individuals with drug addictions. So what we found from the study is there is a sweet spot where most prosecutors leave, which is typically years 7 and 8. So that's when they typically leave the field if they don't become lifelong prosecutors. And essentially they also shared how it was very glaring that individuals with more resources were more likely to be acquitted, so meaning that could afford fancy attorneys. So again, what they saw, these continuous inequities within the structural criminal justice system, that said it's really not about the evidence or the facts, it's can you afford a reputable attorney that can come in, oh that was different, that can that can come in and assist you. My last slide was going to be great. It's all right. So let's talk about the R word that. You can try. It's okay. It's okay. So some of the reform recommendations, because we asked, now that you've left the field, what are some of your recommendations? And so they basically fell into 5 categories. One is the suggestion of systemic structural changes. The second, they recommended cultural shifts within their office. Third, collaborative effort among stakeholders. Fourth would be community engagement. And then the last one is reallocation of resources. So I'm going to briefly highlight those. It's okay. For the sense of brevity. So in terms of the systemic structural changes, basically they no longer wanted to they essentially said the system is corrupt, and they no longer wanted to participate in the current criminal justice system. They said the energy and excitement to do well that motivated them into coming into the field was oppressed by the system. They said that it became very difficult to tune out the tragedy, and them and their colleagues typically just created kind of this hard shell, or these shells of hardness, and that's what made it bearable for them in the sense to continue this, again, emphasis on winning versus justice. In terms of the cultural shift within the office, they said outside of the obvious, again, focusing on justice versus winning, that prosecutors need to be more cognitive of the communities that they're serving. So they suggested making it required for new recruits as part of the training to go into neighborhoods hit hard by prosecutors. Like, how can you change the hearts and minds of prosecutors? They talked about the importance of training on implicit bias, on substance abuse, on mental health issues. With children, the Tamar Rice incident, one of the key components is that police officer was not properly trained on developmental competence. What do I mean by developmental competence? I mean understanding how the teen mind works. And so police officers are trained on how to police adults. And so what we see, as we saw with the Tamar Rice situation, is we see them using adult policing practices on children. So there is training out there conducted by an organization called Strategies for Youth that train police officers on how to interact with children, how to adjust their behavior, language, and timing. The way the teen mind works, it takes them longer to respond to commands. Police officers respond, they're being resistant in their shooting when it takes them longer to process the information. As a quick example, we did this training in Boston with the transit police. Prior to our training, they had 646 youth arrests for the year. After our training, the very next year, it was 74 youth arrests. So that shows you that there is hope, as Professor Davis is looking for, but a lot of it does have to do with training. I'm back. With respect to the last 3, collaborative effort among stakeholders, the participants in the study said yes, prosecutors need to lead the way, but obviously they can't do it alone, and talked about the importance of community engagement, increased accountability and transparency for just getting involved, having community-based policing. And in terms of community engagement, they said, the importance of when you include prosecutors in the community in terms of requiring it as part of their training initially, that it reduces the likelihood of them making these presumptions of criminality or making assumptions about the people. Because essentially you can't make assumptions about individuals that you serve and then think they're going to end up doing justice when you already have these preconceived notions. And then lastly is the obvious, which was reallocation of resources. So the importance of not spending so much resources on these low-level defenses and diverting those funds to diversion programs. So that's my abbreviated version with the technology situation, and thank you very much.
Good afternoon. I'm Ed Monahan. I'm former Chief Public Defender I began as a public defender in 1976, and I'm delighted to be here. You know, I was thinking, sitting here, listening to these presentations and the concept of this program, that it speaks volumes about the University of Louisville Law School and its leadership to have a program with this focus here at the law school. So it's a privilege for me to be here and to be a part of it. I have three simple thoughts. One is Kentucky's criminal. I wanted to, Professor Davis' book talked about policing and prosecutors, and I wanted to put a Kentucky face onto some of the aspects of her thinking so that there could be some Kentucky flavor to what is going on in Kentucky. And, you know, as a Kentucky public defender for nearly 40 years, public defenders are representing individuals in cases where their life or liberty is at stake. The Kentucky Public Defender Program last year represented 162,000 persons charged with a crime at all levels: misdemeanor, juvenile, felony, capital, post-conviction, appellate. So defenders have the responsibility to do the work for a particular client in the courtroom, and that brings to us a point of view from those many experiences. So it's clear to public defenders that the Kentucky criminal justice system has deeply rooted illegitimate racial disparities throughout. It's in the bowels of the Kentucky criminal justice system. On a hopeful note, I believe, and Kentucky public defenders believe, that there are common sense, achievable ways to mitigate these deeply rooted problems. However, this is very tragic. Kentucky has not had in the past a critical mass of leaders, with some exceptions, but for the most part has not had a critical mass of leaders who are aware of and have the ability and commitment and political capital to achieve substantial reforms. And Kentucky currently doesn't have that set of leaders. And my fear is the horizon in Kentucky, there is no critical mass of leaders appearing that have the ability, the desire, and the ability to achieve meaningful reform. Now, you know, I understand, I agree that, you know, mere reform is not good enough. We need structural change. I agree with that. I agree that the problem is not mass incarceration. That's the result of a structural problem. But as a Kentucky public defender, for these years, we nevertheless have the responsibility to try to bring about a better situation for the clients we're currently representing and going to be representing. And one way to do that, one way to restrict the devastating influence of prosecutors who control the system is to change the rules to reduce their discretion. And that can be done in part through common sense reform. So I want to briefly give you some context. Kentucky's prison population increased more than 271% between 1985 and 2015, from 5,700 people in 85 to 20,700 in 2015. That's an enormous increase, enormously expensive increase. Since 2015, that 20,700 has increased to 23,565, about 1,000 more a year. Now, let me ask the room here. How many folks believe that the crime rate in Kentucky is going up, increasing? How many people here that believe the crime rate in Kentucky is staying about the same? How many here believe the crime rate in Kentucky is dramatically declining? Okay, and we've got a lot of no answers. Holding out. Here's the facts. Most people, when I ask that question, the crime rate's going up. And Craig Haney has a theory of why we believe that, and his theory is we all have a PhD in media criminology because we watch the 11 o'clock news. The facts are the following. From 85 to 2015, the crime rate in Kentucky declined by 19%. The violent crime rate declined by 28%. That is astonishing decline. And Kentucky's crime rate is below the national average. Its violent crime rate is below the national average. And to people that question that, here's the verification. Between calendar year 2007 and 2016, the number of criminal cases in the system has decreased by over 45,000, from 254,000 to 208,000. Fewer cases in the criminal justice system. One might say, why do we continue to increase the number of people we incarcerate while the crime rate is declining? And here is the financial cost of this in Kentucky. In 1990, general fund corrections spending totaled $140 million. In 2010, it was $440 million, an increase of 214%. In 2014, it was $490 million, a $350 million increase in 24 years. It's nearly $600 million this year. It's headed to $700 million in the next biennium. And, you know, the legislature every 2 years appropriates money on a prediction of what corrections will need. And the last 6 years, they've missed that and had to do what they call a necessary governmental expense. You give corrections money beyond what they were appropriated because they have more people coming in than were predicted. You add up the last 6 years, and that's $140 million additional dollars. Now, some people say, and this is an understandable question, well, the reason the crime rate's going down so well is because we're incarcerating more and more people. But the research doesn't support that. The research says, at best, at most, 25% of increased incarceration is attributed to the decrease in crime rate, which means 75% of this increase in incarceration has nothing to do with the decrease in the crime rate. Now, let's look at this, at the data. We have about 8% African American population in Kentucky, but 15% of those arrested are African American. 17% of arrests for serious crimes are African American in Kentucky. 22% of our prison population is African American. 30% of our confined juvenile population is African American. The rate of imprisonment in Kentucky, this is data that has a few years on it, shows a stark racial disparity. 425 white inmates for every 100,000 whites in the population. 425 white inmates. 1,412 African Americans incarcerated for every 100,000 African Americans. Now, there's a larger context that we're operating in Kentucky. All of the people we're imprisoning and the people that are imprisoned, African Americans at this much higher rate, when convicted of a felony, lose the right to vote. Kentucky has the third highest rate of disenfranchisement in the nation. 1 out of every 14 Kentuckians are disenfranchised. This is a rate almost 3 times the national rate. Kentucky has the second highest African American disenfranchisement rate in the nation, with more than 1 of every 5 African Americans ineligible to vote, nearly triple the national average. And Kentucky is one of but 4 states that permanently disenfranchise all persons with felony convictions. The only way to get your right to vote back is to get an individual partial pardon from the governor. Now, 2 little examples of how this fits into what Professor Davis is talking about, how what she's talking about is playing out in Kentucky. In juvenile prosecutions in which public defenders provided representation for first-degree robbery, 58% of the clients were African American. For second-degree robberies, the percentage of African American climbs to 67%. Look at theft by unlawful taking, which is a lesser included of robbery. 71% of our clients were white. One has to ask the question, is the discretion being exercised on the charging of individuals with similar factual situation being skewed more favorably for whites and more unfavorably for blacks? One example in the adult arena. In heroin prosecutions of adults in Kentucky, those charged with possession are overwhelmingly white, 92%. Those charged with trafficking, where the penalties are much harsher, range from 28 to 50% black, depending on the degree. The interesting thing that, this is a pessimistic set of information. It'd be easy to not be hopeful. And I think the rational approach is to say Kentucky doesn't have a foreseeable future out of this pickle. But when the polling is done of people, the National Center for State Courts did a poll, and people say current sentencing policies and practices are widely viewed as unfair to minorities, non-English speakers, and low-income offenders, and prone to give higher income offenders preferential treatment. People understand we have a problem. This survey finds a majority, 60%, feeling that low-income offenders are treated worse than others convicted of similar crimes. Just under half of the public on this poll, 46%, feel African American offenders experience discrimination in sentencing. So there are a lot of people that understand the problem. African Americans understand the problem. In this poll, the perception of bias in sentencing on the basis of race was viewed as present by 77% of African Americans taking the poll. One way, as I said, to reduce the discretion, make it harder for there to be explicit or implicit bias in the system, to take a small step towards structural changes. Clearly unsatisfying in terms of reaching the goal of the necessary structural changes would be to have some reform steps that would have good meaning for the 162,000 people that Kentucky Public Defenders represent. A couple of simple examples: reducing low-level misdemeanors down to violations, reducing low-level felonies down to misdemeanors, making adjustments in the persistent felony offender law. Persistent felony offender law, when the penal code was adopted in the early 70s in Kentucky, was focused on career criminals, people who were determined to be incorrigible, people who continue to repeat crimes of a serious nature. Yet, a year or two after that model penal code was enacted, prosecutors came to the legislature and said, change the persistent felony offender law to allow us to charge more people as persistent felony offenders. Because of their successful lobbying of legislators, Kentucky has the broadest application of its persistent felony offender law of any state jurisdiction in the nation. You can be a second-degree persistent felony offender in Kentucky if you've had one previous felony and never served a day in jail or prison. And the corrosive nature of this is, once you're charged with a persistent felony offender law, the sentence range increases, and the risk to you of going to trial increases dramatically. And so prosecutors then often make an offer that is exaggerated in its severity, daring you to go to trial. And unfortunately, the Kentucky law is, if you are found to have been previously convicted of a felony as a second degree or two felonies as a first degree, the jury must convict. They have no discretion. This is one of the biggest drivers of this increased incarceration, and it is skewed beyond measure the purpose of it. I want to end with, automatically restoring voting rights for ex-felons, expand the alternative sentencing community-based program system, expunge all Class D felonies. Only some of them are expungible now. These are some steps forward. I want to end with an observation. This is from the point of view of criminal defense lawyers and public defenders, made by Brian Stevenson. He says one of the most important advances in criminal defense work over the last 40 years. So think about what do you think is the one of the most important advances over the last 40 years in criminal defense work? Think of what that might be. Here's what he says: has been the evolution of skills, tactics, and techniques to contextualize criminal behavior through mitigation narratives. Not only has the work been critical in dramatically reducing the number of death sentences imposed in this country, it's provided lawyers with an important way to think about their clients and the lives of the poor and marginalized who are so overrepresented in our system. So one of the biggest advances is for criminal defense lawyers to learn better how to tell the story of their client, and to tell it in a way that comes from the lawyer himself or herself understanding it better. This is a dramatic change of a way that public defenders are trying to do a small part in communicating what this program has communicated when representing an individual client. Thank you.
Are there any questions from the audience?
Some other way that you all can think of to limit prosecutorial discretion in this way?
So, no, I think all of those can be good ideas. I'm actually, even though I'm very critical of discretion, I'm not at all a fan of getting rid of discretion, because we know we have some examples of how that didn't work. I mean, that's what mandatory minimums were all about, right? So it's decided we're going to take discretion away from judges, because when there's discretion, there's, the possibility of discrimination. But also when you remove discretion altogether and say you've got to do everything this way for everybody the same, That doesn't work either. I mean, that's when they did mandatory minimums. They're like, we're going to take the discretion away from judges. What it ended up doing was shifting it to prosecutors. And so, it still creates, those inequalities. Changing the standard, the probable cause standard, sure, I'm all for that. I think that's something that would be difficult. I mean, probable cause is the standard, the constitutional standard. I mean, trying to get that changed in the long term, I think would be difficult. But even if you change that standard, I mean, if you don't have somebody who's in charge who has a certain vision of prosecution, even with a higher standard, you're going to still end up getting bad results, in my personal view. So I understand your frustration is that, it seems so localized because it's just like city by city, county by county. There's thousands of elected prosecutors. And by the way, one thing I didn't mention is most prosecutors are elected. Federal prosecutors aren't. But federal prosecutors only handle there's only about 10% of all criminal cases prosecuted in federal court. 90% of them are done in these thousands of prosecutor offices across the country. So I think it would be hard to have a way to sort of have some sort of national, way that's going to sort of quickly, a standard that's going to be set, because I still think it's still going to leave so much leeway for individual prosecutors to really do what they want to do. I really do think, and again, I'm not saying that it's a panacea, electing progressive prosecutors, but although it's hard, I think it really is, in my view, sort of the way to go. I don't think there's a way we can sort of say, okay, here's a thing that all prosecutors are going to have to do. And you can certainly get the legislature. You can get the legislature, right? Through legislative change, you can probably get some of the things done, but good luck with that too. If you look at your legislators, I mean, I'm not sure, not just Kentucky, but I think everywhere. So I think your ideas are good. I just think difficult.
Yeah, and one thing I just want to add is that one thing that one of the prosecutors recommended, one of the former prosecutors, is a push to create community accountability review boards, a way of doing it very quickly to where you have increased pressures on prosecutors in terms of accountability. You have in a sense an oversight group that would help essentially say, we're watching and we're paying attention, and anything that we think is an abuse of discretion, we're going to highlight that in the media and beyond, and using that as a pressure force that is financially very minimum in terms of requiring a lot of funding, but yet an effective means of bringing forth the type of systemic change that you're referencing. I say absolutely, and I had referenced in my presentation, that's why I refer to them as the gatekeepers of justice. So even if individuals are wrongfully arrested, the prosecutors have to decide whether or not they're going to pursue any charges. So I think they're, in a sense, the first line of defense, and so I think it is wise to focus more on prosecutorial reform. It doesn't mean I'm abandoning police reform, because I'm a big advocate of training. And one of the things with the implicit bias training is there are some explicitly racist police officers, but the training, in a sense, puts them in the spotlight. We're looking at you as individuals in terms of the racial disparities in your arrests that are being made, and so it's kind of a backdoor way, a smokescreen for addressing explicit bias as well. But I definitely think it's in our benefit, the best approach to focus on prosecutorial reform as opposed to police reform.
And I agree with that. Now, I'm trying to remember, I think it was Larry Krasner. It may have been someone else, one of these other prosecutors, but they decided they were not going to charge certain, we're not prosecuting low-level drug crimes, period. And so the cops would arrest, they'd bring them, and the case would get dismissed, and eventually the cops stopped making their arrests because they knew they were wasting their time because the cases weren't going to get prosecuted. So it can have an impact. And of course, the problem of prosecutors not charging cops who engage in illegal behavior, from killing people to other illegal behavior. And I have to stress what Paul said. Read the Ferguson report. It will just blow your mind. Unconstitutional behavior that was going on there that I'm sure is going on in many cities across the country. But it's so easy for prosecutors to bring charges. Like, you know, the old saying, you know, a grand jury will indict a ham sandwich. I mean, it's so easy to indict, but yet they won't indict these cops, right, because of that incestuous relationship that they have. They rely on cops all the time to, you know, make their cases, and so there's like inherent conflict there. But I think with prosecutors, you know, changing sort of how they approach those cases and making it clear they're not going to stand for that behavior. They're going to dismiss cases where cops behave, you know, illegally, where they violate the Fourth Amendment, where they do worse. It absolutely can make a difference, but you need a strong prosecutor who's willing to do that.
Easy crowd. Yes, go ahead.
I have a question about that because you mentioned grand juries. So, like, do you believe that we should do away with grand juries altogether? Like, do they have any use? Are they just such a rubber stamping mechanism at this point that there is no use to them, or is there reform to be made in that arena as well?
So, go ahead. You can go ahead, Laura. Okay. So the chapter in the book on grand juries, which was written by Roger Fairfax, who's done so much work on this, is a really good chapter and interesting. He has all kinds of ideas for reform. I mean, the grand jury, in theory, the idea is that, so we don't want to put all this power in the hands of one person, a prosecutor, so we're going to have a jury of your peers. Usually it's not the 12 for a jury, it's like 22, 23, but they're controlled by prosecutors. So without a change in the rules with how these grand juries operate, they don't mean anything, in my personal opinion, the way they're currently working, right? So prosecutors can put whoever they want in the grand jury. They're not required, even if they have exculpatory evidence. In other words, if they have evidence that shows the defendant did not do it, they are not constitutionally required to give that information to the grand jury. There's a Supreme Court case that says that, right? And so they totally control it. Defense attorneys don't have the right to be there. The defendant doesn't have the right to be there. They can put in who they want to, not put in who they want to. So, yeah, the way it's currently operating, I don't think it's very meaningful. I mean, if there were changes made in the way the grand juries work, possibly they would work, but the way they're operating now and without serious reform, no, I don't think it means a lot.
It's easy.
Just a question for I mean, I think, Angela, you kind of touched on this, but the common refrain amongst reform-oriented police chiefs is that there's no shortage of good ideas, but entrenched occupational culture, coupled with collective bargaining arrangements, makes the implementation of progressive reform-oriented agenda kind of impossible. And it sounds like you said that there may be similar impediments in the universe of confronting a progressive DA who's elected, maybe not in Philadelphia. Do you have any sense of what the landscape looks like in terms of this stuff?
Yeah, really good question, and it varies from jurisdiction to jurisdiction. So I just mentioned Larry Krasner. He was able to go in. He fired 31 people. Not all prosecutors can do that. So I'll give you an example. I know we're very quickly. So another reform, progressive prosecutor is a woman named Aramis Ayala. Anybody ever heard of Aramis Ayala? Aramis, last name Ayala. African-American woman, first African-American DA for Orlando, Florida. She came in with a real progressive agenda, made a public statement. I'm not quite sure why she made a public statement, but she made a public statement, I'm not seeking the death penalty, period, right? I'm thinking, don't say it, just don't do it, right? So, of course, when she made the statement, the governor came in, and Rick Scott, and basically said, okay, I'm going to remove you from all of the death-eligible cases, right? Came in basically and gave all of the death-eligible, by death-eligible, I mean murder cases where it is possible for the prosecutor to seek the death penalty, and put them under the control of a prosecutor in another jurisdiction that was not even elected by the people of Orlando. Sounds crazy, sounds illegal. She filed suit represented by Roy Austin, who used to work in the Obama administration, went all the way to the Supreme Court of Florida and lost. And this happened in New York also with Bob Johnson many years ago in the Bronx, who did a similar thing, said, I'm not seeking the death penalty, and the Republican governor at the time removed him. So it's complicated, right? Because prosecutors who go into those offices, usually they're dealing with career prosecutors who've been in there for many years. Not all of them are with the reform program. So I think that's the next step in this whole great idea of getting elected prosecutors. How are we going to help these progressive prosecutors actually implement these reforms, particularly in jurisdictions where they don't have the power to remove prosecutors? Kim Fox in Chicago, fabulous, amazing. That's another person I encourage people to look up and listen to her podcast. I mean, she's amazing. African-American woman, Chicago, tremendous. I mean, but Chicago, I mean, with all of its problems, going in there and trying to change the minds of the people in that office, that's the next big challenge. I think it can be done where the laws permit. I think hard decisions have to be made. People have to be fired, but in some cases they can't be. And so it's about trying to move those people along in the office, meet them where they are, and train them. I'll mention one more name. What is this? Dan Satterberg, who is the DA for King County in Seattle, Washington. He actually is not a newly elected progressive prosecutor. He's been in there for decades. But he's somebody who's actually a decent prosecutor who's trying to implement change. And so, you know, he makes his prosecutors go to school. Like, he made them read Michelle Alexander's book. They had to have class. Then he made them read my book. I mean, he's doing what he can to try to, like, slowly but surely, like, educate them and bring them along gradually. And, you know, because the chief DA can't be in every courtroom where all their DAs are. So there's more than a notion. I mean, so I appreciate your question. Those are some of the ways that some of these prosecutors are trying to deal with what you identify as a serious problem.
In Kentucky, on the public policy side, when prosecutors have stepped out publicly and supported legislation like Class D felony expungement or DNA testing for post-conviction cases, they report that they're ostracized amongst other fellow prosecutors. And that's a pretty big deterrent.